Today's episode was an awesome deep dive into case framing with my good friend Patrick Kang from Ace Law Group in Las Vegas, Nevada. We broke down how to simplify tough cases, shift the jury's focus to what really matters, and use focus groups and corporate rep depositions to build winning themes for trial. Patrick also shared great insights from his $15 million MGM slip and fall verdict and how mindset and framing make all the difference at trial. For those of you who don't know Pat, some of his recent results, $38 million wrongful death verdict for an 11-year-old child who was killed in a crosswalk by a Republic Services garbage truck. That was a case he tried with Sean Clagett's firm. He had a $1.5 million verdict against a president and founder of a private company in a hotly contested he said versus she said sexual harassment case. A $6.6 million verdict on a complex toxic mold poisoning case against a prominent property management company. And most recently, a fantastic verdict that we're going to talk about today, a $15 million verdict against MGM for a slip and fall case at the Cosmopolitan Hotel and Casino out in Vegas. With that, Pat, welcome.
Thank you. Thank you for having me. It's nice to finally meet Robert too. I've watched a lot of your guys' TLU videos, and thanks to you guys sharing your knowledge, I've actually been able to use a lot of that in my own trials. So it's been a blessing, and I've been following you guys for a while. So whether you
Yeah.
know it or not.
Yeah, happy to have you here. A lot of the guests we're going to have on here are actually connections that we made through Trial Lawyers University. So if anybody's listening and here's TLU and they don't know what that is, it's Trial Lawyers University. It's a fantastic organization run by Dan Ambrose. Probably best known for the TLU Beach out in Huntington Beach, which is a seminar, multi-day seminar where the best trial lawyers in the country go to put on lectures and lecture tracks on specific topics, whether it be cross-examination, opening statement, focus groups. There's a lot of trial consultants that speak out there. So Pat and I think, met the first time, was that Vegas, or it must have been Vegas.
Yeah, I was at the golf outing at TLU Vegas. I actually made it a
That's right.
point to come out and seek you out. I don't know if you remember that. And I think you were kind of like, "Who is this guy?" I'm like, "Hey, I watch your." It was the ice slip and fall on ice case that you guys did a couple years back. That you did a video and case review on, and that was extremely helpful. And we've talked about this before, Mike, where there's a lot of information out there now, which is awesome. A lot of books, a lot of podcasts, a lot of videos, a lot of case analysis. But if you take all of that, that's just too much information coming at you. So, you got to kind of sift out what makes sense to you. And the way you guys did that trial just made complete sense to me. And I've adopted that motto kind of ever since. So,
Yeah, appreciate that. I think we do have a very similar way of looking at cases and preparing for trial. I've learned a lot from you, and I think vice versa. So today, I think it's going to be fun. We're going to talk about case framing, which is a topic that I think consistently comes up at most high level trial lawyers conferences, and something there's a lot of content out there on case framing. And just to set kind of the scene for our discussion today, I always like to start with a definition, because case framing is kind of an umbrella term that covers a lot. But when I think about case framing, really the way I think about it is what you choose to focus on as a trial lawyer, and the story that you're telling the jury, that you're choosing to tell the jury. Uh, so I'm curious, with this $15 million result that you got. We did a TLU breakdown of it, so I have a pretty good understanding
yeah.
of the facts surrounding the case. But in simple terms, it's a slip and fall case at a casino, which I think a lot of lawyers, whether they be in Vegas or elsewhere, just in general, don't really want to touch slip and fall cases. There's a lot of defensive attribution concerns around um, why the client didn't see the dangerous condition. A lot of people are concerned with proving the case. So, tell me a little bit about how you think about case framing and how you think about it on a tough case like a slip and fall case.
Well, I think ultimately, in this is something I borrowed from your slip and fall on ice case. Is you start with this is a simple case, and if it's not a simple case, you're in trouble because you're going to lose. So the way you want to start, you got to figure out from the get go before you get into the case framing. How is this a simple case? And really, ultimately, every case has kind of this three-step process. A major corporation, a national company, a state company, they failed to address a safety issue that caused permanent injuries to my client. It's three. So that's really every case ever, right? So if you just start there, it actually becomes a lot more simple. So it has almost this self psychological effect as well as having that, psychological effect on the jury saying it's a simple case. You're telling yourself and convincing yourself, and then it actually becomes a simple case. And then from there, the case framing, just as you say, it's all about what you focus on. The beauty of being a plaintiff's attorney is what we focus on is the narrative of the case. So, I always break it into three, which is the story, the themes, and the landmines. So that's how I start. So once you figure out this is a simple case, major corporation failed to address a safety concern causing permanent injury to my client. That can be attributed to any case, right? So in Debbie Fenton's case, it was, the Cosmopolitan failed to address a safety hazard that caused a permanent injury, a forever injury to Debbie Fenton. And that could be also in a toxic mold case. A national property management company failed to address a history of safety issues that caused permanent injury to my clients, Anna and Keena Andrews. So it's a thematic, keep it simple situation, and I think you guys use a very similar approach to that, right?
For a lot of lawyers, when they look at a slip and fall case, we talk about in marketing like the purple box. And I think when you're thinking about the language of the case, like you said, when you're talking about themes, is it an accident? Are there minor injuries? These are defense terms that a lot of lawyers will look at trying to explain. It wasn't an accident. It wasn't a minor injury. And if you're starting on the low ground like that, and you're having to explain everything for the jury, that's a losing frame. I think an easy way to kind of test if your framing is good or bad is to ask who's having to explain the case more, our side or their side. And when you mentioned corporation or corporate responsibility, corporate policies, procedures, you're already starting a frame of they need to explain their behaviors. It's not about us explaining our behaviors. They need to explain why this happened, not us. And I think that that requires a mindset shift. And what I'm curious about is how long did it take you to kind of for that to click? Was that something that was intuitive to you right away? Is that something that evolved as you tried cases? I know you've tried a lot of really hard cases. So I'm curious to know kind of the evolution of your thinking on that.
I would say there was definitely, and it didn't click right away for sure. I wish it did. There's definitely attorneys out there I've spoken with. It seems like they just get it, from the get go. But it took me a while, and I think it's because when you start off, there's already kind of this set, whether you want to call it tort reform or whether, I've thought about this. Most attorneys, when they start their career, they don't start off as a plaintiff's lawyer, right? Because those are smaller firms. They tend to start off in bigger firms that are defense firms. So they get indoctrinated into these ideas like, well, it's a car accident. It's a minor impact soft tissue case. Well, when you evaluate cases, you want to take the medical bills and then you want to multiply that. And you kind of get this in your head, right? And this has been in my head from really the first few years of practice when I started practicing. And that's what everyone tells you. That's what mediators tell you. That's what defense counsel tell you. That's what adjusters tell you. That's what your own peers tell you in your own firm sometimes. So the hard part about what that was getting out of that mindset. And when you really step back, and I believe the first time my mind was truly opened up to that was reading the reptile theory, getting into Don Keenan and David Ball and their ideas about damages and reptile theory. I believe that really opens it up. What are the rules, and what's the defense or defendant or the corporation doing about the rules? Are they following the rules? How are they not following the rules? And you really, from Jump Street, you go on the attack, and that is, I think, kind of different from how it used to be, where you used to think, well, what did my client do? What did my client did he break too quickly? Did he did he suddenly stop short? What does that matter? It took a while to get out of that mindset. And I think the first time I really experienced that was when I read, the reptile, and that really opened up my mind. Now that I love when we get these. I don't know if you guys still get these, but defense will file motions in limine on reptile theories, and it kind of makes me laugh because that's kind of like antiquated. Yeah, right. We've evolved so much from that, but uh, really, I think that's where it started, and then from there, people start building upon it. And Keith Mitnick took me to another level. So when I read his "Don't Eat the Bruises" book, that took me to another whole nother level, and I realized this is, like you were talking about the purple box, like this, they want us to focus on this. They want us to talk about the minor impact soft tissue. They don't want us to look outside this box. They want us to focus on this little box and this 2 minute time frame where there was a spill and our client slipped in it. And that's where they want us to, they don't want us to go back in time when it really matters. So having that mindset shift really kind of changed everything for me and for everyone here at my firm, at least. And once we started focusing on that, and that's where we poured our focus. And, they call you like, well, it appears your client, may have had a subsequent a crash 3 years later too, and we don't know. That's okay. You can fight about that all you want. She still had a spinal stimulator recommendation before that crash. There's always ways around the damages where you can explain it. Oh, I had a car crash case in 22, and this is where I really explored the Mitnick, the Mitnick way of doing things, where he kind of preaches like, look, if there's a surgical injection and there's 6 months plus of treatment, this is $1 million case. You know why? Because they have a permanent injury. They have herniated discs in their neck or back or their spine, and it's only going to get worse from here as time goes on. So that was the first time I tried it in that manner, and I noticed, it was against an insurance company, and their big thing was, well, there's a 36-month gap in treatment. So all you have to do is ask, and once you get the liability portion down, you attack. Well, here's the rules of the road. Here's how you violated it. Then you focus on they're going to attack the damages, right? So, I went to my client and I said, well, why didn't you get the injection? What was your reason? And her story made 110% sense to me when she told me, well, when I was a kid, I had a very, very volatile reaction to pain medication. I had to go to the hospital for it. And I've never, I won't even take Tylenol since then. So the idea of them injecting, pain medication into my spine horrified me until the point where I couldn't take the pain anymore. 36 months later, I finally said, you know what? I don't care. It hurts so much. Put whatever you need to inside of me in order to heal me. And that was a game changer. I was like, well, that makes sense. So if that can make sense to me, you can't make sense out of the fact that they were speeding, they were drunk driving, they didn't follow the rules of the road. You can't make sense out of that. You can only make excuses. So once you have that mindset shift, that I really changed everything.
So, Patrick, one of the things that while we're talking about this, I started thinking is we already start out. We're all lawyers. We're all talking about case framing, but we're already talking about a slip and fall, right? And that's that frame is focused on our client. What did they do wrong? Why didn't they see it? Just like
Oh,
you're saying. And that's one of the things. It's so easy to fall back into those frames without even realizing it. So tell us, what do you do with your mindset to try to, I guess, first of all, realize when you're falling into that frame, and then what do you do to get out of it? Because it's an easy trap to get into on all these different areas.
well, I think I do what you guys definitely do, which is you have to focus first on what they did wrong, right? So if what they did wrong is there, and it's pretty clear that they ignored some clear safety hazards or danger signs, then you think, well, okay, what are the landmines that my client can fall into? So the natural instinct, and you do this a lot in focus groups, right? You get this a lot. So you tell them about a slip and fall, and you can kind of feel when people are against you because they'll say, well, what kind of shoes was she wearing? How many drinks had she had? Was she walking all day? Is she used to walking in heels? Is she used to that? And I wanted to be like, are you serious? Is that is that so you look, there's broken glass everywhere. That's what you want to focus on. You want to focus on what my client was wearing, the shoes. And I think that actually stems from my experience in sexual harassment cases. So my experience in sexual harassment cases, this is before COVID. I don't remember what year it was, but it was a case against IHOP, and our it was an underage kid who was sexually like a 15-year-old girl who was sexually harassed by the manager there. And I remember sitting in there, and we were discussing after a deposition. I was talking to the defense attorney about the possibilities of resolution, and he started firing these questions at me. Well, did she ask to be driven home by my client? Did she ask to be? She gave him her number though. And I looked at him and I said, she's 15. She's 15. Are you really trying to turn this around? And I couldn't fathom that kind of direction. But then as time went on, I saw that this, you can label it what you want, victim blaming, victim shaming, but it applies to injury cases as well. Whether it's a slip and fall, whether it's a car crash case, no matter what it might be, it's something that's the tendency that you see is they want to shift it back to you. So once I kind of with that experience in mind, I kind of realized there is this want to do that. So I have to stop myself also because it's so indoctrinated in our heads. I have to stop myself from well, what was she? Did she drink a lot? Was she? Is she healthy to begin with? Maybe she does have pre-existings. Once you realize and you kind of tell yourself, well, that doesn't matter. What did they do? Let's start there. So I always have to walk myself back, and if there's something they did wrong, like for example in the slip and fall case we just did against MGM Cosmopolitan, we have a 3 minute and 26 second video, and if that's all we focused on, and you tell a jury it's 3 minutes and 26 seconds that the spill was there, they're like, that's not that long. But then you show it to them and you get outside the box. Well, here's their policies and procedures. Here's what they're supposed to do. They have a see something, say something policy. If you see a spill, you secure the area. It doesn't matter if it's Saturday fight night in Vegas and it's the busiest night of the year. You still have to secure the area. You have to phone in help. Everyone's got radios now. Stop what you're doing. Block the area. Secure it. And that's something, you if you focus on what they did instead of what your client did, that's when you kind of realize, okay, there is something here. There's something here because what was this guy doing? And Mike, if you remember the video, then it was even better because he's talking to Michael Jackson impersonator, and they're looking at his Instagram, and it really just inflamed and infuriated a jury. But the reality is, if you really focus on what they did and what went wrong on the Cosmopolitan side and what they should have done, it's really a common sense aspect to it. Most people would say the same thing, and that's what you test that in focus groups as well. And I think that was really helpful because I would say like, well, what if he was busy? What if he's busy? What if it's Saturday night? It's fight night in Vegas, one of the busiest nights of the year, right? You can't just sit there and guard broken glass, can you? And they would say, absolutely, you should. Because we have radios now, there's technology where you can call in help. Anyone can spare 5 minutes. Anyone can spare 5 minutes to sit there and say, excuse me, sir, ma'am, watch your step. And you just saved two lives.
Mhm.
So
Yeah,
that
no,
kind of,
it's interesting that you bring up focus groups because, I mean, obviously, we're talking about case framing as what the jury chooses to focus on. Focus groups are obviously a really good opportunity to see, especially when you just lay out the facts. Because, when you start a case, the facts are the facts. Juries make decisions based on what the facts mean because the
right,
facts are the facts for both sides. This shift of who's prosecuting, who does the story belong to? Does it
yeah,
belong to your client or does it belong to the defense? The neutral focus groups, when you first get involved in a case, this is where it started to click for me because we would lay out the neutral facts of the case without any framing involved,
right,
and we would see where the framing, what direction it gets pulled in, and where the questions are being directed. And then you see if the questions are defense oriented or they're around defensive attribution. Why didn't your client see the glass? Why did they walk over the glass? Why were they in that area? You understand, you start to see where the purple box is.
right,
We all know as trial lawyers, like we kind of have expectations about where that box is going to be set. But when you actually start talking to people and they start raising these things, you start to see, okay, these are the battles I don't want to fight because these are the battles that are going to be 50-50, where it's going to require the jury to make a decision about their belief. Do I believe they didn't know? Do I believe they did know?
right.
And one thing that we would see is we would do the neutral focus groups. We would see those questions being raised. And then we would, ask them, what's your knee jerk reaction on who is responsible? And you'd have just opinions all over the place. You'd have people, 100% on the plaintiff, 100% on the defendant,
Yeah.
somewhere in between. But then once you do a focus group where you kind of start to bring framing in, that's when you start to see consensus. And what's interesting is what really drives the difference, in my opinion, is who the story belongs to. And so once you
100%.
start putting your foot on the gas and saying, no, we're going to keep directing the focus towards policies and procedures, their prior knowledge, there were prior slip and falls.
Right.
They had 10 minutes of notice about this dangerous condition before it got more dangerous or whatever it might be. That's where you really, at least for us, we start to get confident in, okay, here's the winning frame. This is where we have the high ground. What I'm curious about in this casino case is, did you do focus groups early on, and what insights did that give you as to what the participants were focused on, or what kind of evidence or facts you should be trying to look for in discovery?
So absolutely. So we did a lot of focus groups on that case, and how we do it, we tend to do neutral focus groups. That's how I like to do it. But I do practice. I don't know if framing is right, but presentation of facts. So how, and that goes to the idea of what are you focusing on. So if I tell the story from plaintiff's point of view, she woke up, she ate breakfast, she went to a convention all day, she got ready for this happy hour, she walks from Bellagio to Cosmopolitan because she likes being outdoors. That's not that's the focus is all on the plaintiff. So I don't start the story that way. I start the story like, hey, have you guys ever heard of the Cosmopolitan? Well, this is the Cosmopolitan. You heard of the Chandelier Bar? This is the Chandelier Bar. Chandelier Bar has three levels. It's a luxury bar restaurant area that they flout this specialty cocktails and have people come and enjoy themselves. So you go there and then you show them this is level 1.5 and this is where our story starts. So I focused our story there, but I did a neutral presentation, Stu. So I still present it like it's neutral. I don't try to inflate anything. I don't try to press any views on it. I just tell the facts, like you're saying. And then I notice this is stuff they latch onto. This is stuff they like, and this is stuff they don't like, and then you just keep tweaking it. So we did, I want to say, 4 or 5 focus groups, and every time I would tweak the presentation a little bit, and I would start using the language that the focus groups would give me. For example, and I wouldn't point it out. I'd wait till they point it out, and then I would start using their language. And then by the time you get to trial, you have the presentation, you have your framing, you have your themes, you know what landmines to look out for because they'll say, well, what kind of shoes? And then immediately that's poo-pooed, by most of the focus group people. They say, well, any woman who goes out to for a night on the town with their husband is going to wear heels in Vegas. They're visiting. So that was almost, there was one person who kind of brought it up one time that immediately poo pooed. So you latch onto those and you just kind of, I don't know about how you guys feel after you get a couple good successful focus groups in a row where it's just kind of like this unanimous feeling. I feel bulletproof at that point walking in. As long as you're listening, right? You got to be listening to your focus groups. But I feel bulletproof. So I go in. I know this is what folks care about. This is what folks don't care about. And what's funny is the stuff here that they don't care about. You almost kind of like raise them for those defenses. Like, well, here's what the MGM is going to come in and say. They're going to come in and say, like, what kind of shoes was she wearing? And by the time you get to the landmines, and I know I'm jumping ahead but like openings, when you talk about your landmines in openings, you got to get ahead of it. But you almost make it sound like it's silly. This is,
Yeah.
well, here's the story. Here's the focus. Here's what they should have done. Here's how they failed my client and how the failures that happened. Here's what they're going to come and say, guys.
So Patrick, one of the things that Michael and I have really talked about lately is this sponsorship theory. And I know we all do these things in our opening where we talk about the undermining, and it sounds like from what you're saying, at least in the focus groups, you're figuring out the sequence and who you're focusing on the defendant's actions. And then I think we all are going into like this, defense and undermining that defense. We've really been talking about this theory of whoever introduces this evidence is saying it's important and that the jury should consider it because it's a danger to the case. And I'm just wondering, how in your case did you do the undermining? I know you talked on the TLU podcast about sort of the devil's advocate in jury selection, and just, I guess, tell us how does that play in? Do you start it really with the devil's advocate in jury selection and then undermining? What's your take on all that?
Yeah, I think when I heard Sari de Lamont talk about and talk about how she gets the principles and sources the principles from the jury, and then she does the devil's advocate questions, that just made so much sense to me. And if you start, the devil's advocate questions are, of course, attacking the landmines in your case. So, you go into that, well, it's a busy night. What if it's a busy night? What if it's too busy? What if the person's in security and they should be doing security things, not cleaning up a mess? You do those devil advocates questions and they give it to you. Like, well, no, they should still, if they're in security, they have more of a duty to secure the area. That's
Yeah,
what
and just so people know what we're talking about, when we say devil's advocate, we're basically we're taking the defense arguments and making them seem ridiculous, or how do you do it?
Well, I think I don't think you want to be like that obvious, right? I think there is a little bit of practice, like you want to practice how you question that. But when you say, at least in voir dire, when you do the devil advocate questions, at least the way I do it is, I say, what about this? What about that? I don't try to make it obviously ridiculous, but if they make it ridiculous, I do run with it. Like, no, that's crazy. If they say things like that, I'm like, well, is it crazy? What if it's busy? What if it's too busy? What if it's Super Bowl weekend? Come on. What if it's March Madness? It's Vegas, guys. It's too busy. And I just keep building that hill for them to kind of, and they have fun with it. It felt like, at least the last time I did it in this last trial, it felt like the whole panel, they were enjoying just kind of, arguing with me about how silly I was being, doing these devil advocate questions. And I don't think they really, maybe some of them did, but I don't think that we were just talking. And that's how I did it. I was just talking to them.
Mhm. Yeah, because I think one way to think about it is when it comes to sponsorship, in football, you have like time of possession, and each team is looking to possess the ball as long as possible. The way I think about it in trial is who has the longest duration of focus. Is it your side or their side? And one, I guess, balancing equation is when you're up there delivering your opening statement and you get to an undermining section, what do you choose to address? Because you don't, one school of thought is maybe Mitnick style, like address everything and put it into context and make sure that when they get up, that they're not going to have anything left. Another school of thought might be the more that you spend talking about their defenses, you're signaling to the jury that those are legitimate defenses that have to be explained. And so I guess what I'm curious is, because I know you did a really good job with this case, whether it be through focus groups or things that you learned during discovery, how do you make decisions about which defenses you're going to undermine or address and which defenses you're going to leave to them to bring up?
So I learned a couple trials ago that addressing every single defense that I could possibly think of was a mistake for me, because that just, at least the way I practice, and I never would I profess everyone should do it this way. People should do what they feel is makes sense to them and comfortable for them. But the way I look at it is, I don't want to give too much voice and too much power and too much focus to something that I don't think is a big deal. So what I try to do, because if you let me, I will attack everything, right? I'll sit there and I'll say, oh, they're going to say this, they're going to say that, they're going to say this, and I'm just going to go. For example, like in the slip and fall case, I knew that the heels were not a big deal. I knew that was not a big deal, so I didn't even bring it up as a landmine because I knew they were going to bring it up, but I didn't care because the focus groups told me not to care. Because when they would talk about it, they would immediately, whoever would kind of bring that up, as soon as they worked through it, it would kind of get poo pooed. So I decided, well, let's figure out, and I try never to do more than five. I don't know why five. I just picked that number kind of arbitrarily, and it's worked. At least the past couple times I've done it, it just feels like a good number. You pick five, and usually like two or three on the front end, all liability landmines to address, and then one or two damages landmines on the back end. So I just kind of go through that, and I try to pick at least one landmine that I know that they'll say that I feel is their most ridiculous approach, and I point that out. I point that out. I say, well, this is what they're going to say. They're going to say this. You guys decide if that even makes sense. You guys get to decide that. And when I'm saying that, exactly what you guys just did, nod your heads, they're sitting there, they're like, yeah, they're kind of like, no, that doesn't make sense. That's the body language I'm getting. Kind of this, yeah. What are you talking about? Are they really going to say that, Patrick? I feel like that's what they're saying to me sometimes with their body language. And I want to be like, yeah, they're going to come up and say that in like 5 minutes here. And sure enough, they do. They don't say it exactly the way I did, but actually in this last trial, I noticed that they couldn't help themselves but to start using our language, right? Couldn't help it because they wanted to say, Mr. Kang, he's quite passionate about this case and his client. Well, so am I. And he says, we're going to blame his client. We're not going to do that. And because that was one of my things. Like, they're going to come up here, they're going to blame Debbie Fenton. They're going to say she's somehow at fault for what happened here. You guys decide if that's true or not. You guys decide. And then they came up there and they're like, so there was one or two choices at that point, right? That defense can do. They can say, you know what, we are going to blame her, which is probably what they should have done in a slip and fall case, but they didn't. Instead, they backed off and thought, we're not going to blame her. That poor lady, she's so nice. Look at her. We wouldn't do that. What we're saying is that there's a mystery. There's a mystery that happened here that we don't know why it happened. It's just an unfortunate situation. Yeah, it's an accident. And hindsight's 2020, right? But we did nothing wrong. That was actually something, and I don't know if you guys, I'm sure you guys do this, but when you're going through trial, they always kind of bring up these kind of their own themes, right? So you can start noticing that, like hindsight's 2020 was a theme of theirs from this trial. And by the time we got to closing, I'd heard it so much, it was pounding in my head. And I just remember thinking, that doesn't make sense. So I actually sat down and, you know, borrowed a page out of Keith Mitnick's book where I just sat and thought about it. Like, why is that not right? Why is that not? I kept asking, like, why does that not? So I looked up the definition of hindsight's 2020. And hindsight's 2020 means, in hindsight, I would have done things differently because I did it wrong. That's what that means. And that's not what they were saying. And I thought, that's beautiful. So I'm going to go out there and I think after I did kind of my whole opening spiel in my closing, let's talk about hindsight's 2020 for a second because you heard that from MGM 10 million times, right, guys? Let's talk about that. What's that mean? What does hindsight 2020 mean? Doesn't it mean in hindsight I would have done things differently? And is that what they're saying? And I don't know what other jurisdictions can do, but in Vegas, in Nevada, we can clip trial testimony and we can play that in our closing because that's evidence. So we clip the part where he says, where their corporate reps said, so you did nothing wrong, correct? We did nothing wrong. And then I clipped the part where he said, yes, hindsight is 2020. And when you put it together, those are two conflicting ideas. And you could actually see the jury be like, yeah, that doesn't make sense. So the theme blew up in their face. Yeah. If hindsight really was 2020, you'd be saying you did something wrong. And what's weird is I've heard that before in other cases. I just never figured it out till this trial. I don't know why it clicked in my head, but I've been in other trials before where they're like, "Look, hindsight's 2020," and they would just kind of throw it to the wind. Like, well, you know, should we have maintained the truck more, the armored truck more? Sure, but hindsight's 2020. They would just throw that to the wind. And I never really latched on to that. But this time they had said it so many times, so that just doesn't make sense. So.
So speaking of corporate rep, for those of you that may not be aware, if you're listening and you don't know what we're talking about what are commonly referred to as 30B6 depositions. And these are depositions where a company is required to speak under oath through a representative that it appoints and it chooses to speak about certain topics that are designated in a notice that, as the plaintiff's attorneys, we get to designate what those topics are. I'm curious, when it comes to case framing, how do you use these 30B6 depots to advance the case frame that you've learned is going to be successful in the focus groups?
Well, I personally believe that corporate representative depots, 30B6 depots, are critical to trial. And because of that, every time we do a 30B6 deposition, I prepare questions directly, well, not directly, but kind of parallel to jury instructions. So in a way that I know a jury will understand. So you can't ask, hey, do you have a duty to do this? You have a duty to do that. You have a duty to do this. That's an easy legal conclusion objection from defense, right? So I just flip duty to responsibility. So are you responsible to make sure that your floors are clean of debris? You would agree that a broken glass is a safety hazard, right? So you have a responsibility to make sure that your floors are clean and clear of safety hazards, right? And you ask those are obvious questions. And I have had from time to time corporate reps say, no, we don't have that responsibility. And that's actually a great response, because you don't have a responsibility to keep your floors clean. And then you want to follow it up with the obvious, like, so you're saying you don't have a responsibility to keep your floors clean? Well, no, I'm not saying that. Well, what are you saying then? Because you just said you don't have a responsibility to keep your floor is clean and free of safety hazards. That's debris, right? That's what we're talking about. We're alleging there's debris in this case, right? And so there's no good answer there for them. So they can say yes, which is what you want, and they can say no, which makes them look unreasonable. And if they say no, you keep hitting that. Like the really smart ones, and this is one that it took me. I don't know if you guys have ever had this, where they tell you define safety hazard. And the first time I heard that, I didn't know how to respond. I was like, oh crap. So instinctually, I just said, well, you define it. What do you think a safety hazard is? And then they answered, and I was like, okay. So this is how I need to respond somehow. So from then on, I kind of prepared for that possibility. And every once in a while, it would happen. Well, I don't know what your definition of safety hazard is. And the last time that happened, it was with a casino rep, and he was the director of safety. So I said, well, you're the director of safety, right? You're in charge of safety. What is your definition of safety? Because you're in charge of that department. You define it for me. You should know that, right? Because you're the director of safety. And they feel so like it's like a cringeworthy moment for themselves that they're like, oh yeah, yeah. Well, let me tell you about safety. Safety is clean floors, no debris. We should have 15-minute rotational. I mean, they overplay their hand almost then at that point. It's wonderful. Um, so that's how I try to frame it. Everything else, there is like a fact finding portion of it where you're like, well, so what kind of training, is it online? Is it in person? Do you do it weekly? Do you have agendas? Do you keep sign-in sheets? So those are a little bit fact finding, and that helps for the discovery aspect, because if they tell you, yeah, we have sign-in sheets for safety trainings, and you don't have those, you're like, well, you're gonna have to give those to me now, and I'm gonna reserve my right to recall you when I get those documents. But what I really enjoy is those questions where I'm laying out what I know I need for trial. And what I've started to do is I'll ask, because they're the corporate rep, I'll ask them like, so you work for the casino. The casino it's 200,000 square feet, right? Well, that's what it says on your website, right? You've never looked at your website before? You want to go to your website? I've got it here. Would you like to see it? He's like, no, that sounds fine. Because they don't want you to go through their own website. So usually, I go through that basis, like, and your casino actually owns other casinos and operates other casinos, right? Some here in Nevada, some in Missouri, some in Ohio, some in Michigan. Is that right? Yes. Okay. And so you're already building your case frame for opening. So why can't in opening then I go, well, this is a national corporation that owns and operates casinos in Nevada, Missouri, Ohio, and Michigan. How can they object to that? I already got it through their corporate rep, and it's binding testimony. So there's stuff like that too. Like I mean, if you've done one trial, you know what you need for the rest of your trials. I feel like.
Yeah.
So then you just start getting in the habit of doing it.
So, something that we've run into a lot, I'm sure you've run into it, a common strategy for corporations, instead of actually complying with the entire purpose of a 30B6 deposition, which is to send the most qualified, knowledgeable person in, they'll send sort of a sacrificial lamb in that either doesn't have any knowledge or pretends not to have any knowledge. And almost every answer will be, I didn't review that. I don't know. I don't recall. I'm not sure. You'd have to ask somebody else. For, I don't know if you've had experience with that, but if that's
I've seen a lot of that. And so it usually comes from one of two types of corporate reps. The sacrificial lamb, that's a great way to put it. I love that. We're going to start using that. Sacrificial lamb, and that is some like, oh yeah, I'm a newly minted manager of the department, right? That kind of person who's been there. So for that person, I just press that. I'm like, so because there's some obvious stuff that is out there that if they say they don't know exists or not, then you can press them on that. Like, well, so what are the policies and procedures as far as training for identifying safety hazards? Well, I don't know. I didn't review that. Like, do you have it? Like, I think we have it somewhere. Like, so how long have you been with the company? 12 years? Okay. So in your 12 years, have you ever had a training on identifying safety hazards? Oh, yeah. Yeah, we've had those trainings. Okay. When's the last time you had it? We do it every year. We do it every year. We do safety trainings every year. Oh, really? Okay. How do you do it? Like, is that in person? Is it online? Is like, oh, well, we have a portal that we log into, and we're required to do trainings every year. And that portal logs everything that we do. Okay. All right. So you have an employee login portal. What's that portal called? Oh, it's called whatever, right? Okay. So the whatever portal, you log into it, and that should have every single safety training class you've ever taken. Yeah. Okay. I'm going to need that. And then I'll just lay the foundation and I'll chase that tail down. That's what we call it here. Like, don't let go. Chase the tail down. And what that means is if they don't let them slip out of that, if they have training, there's some obvious questions you can ask. Like, everybody has this. Everybody has this stuff. You're a major corporation. You must have training records. We're going to get those. And after we get those, you're coming back here and I'm going to ask you questions about them. And then I'll even ask them on the record. So once we get those, are you going to review those so that we can have a meaningful conversation next time? Well, how do they answer that? If they say no, that's ridiculous. They're going to say yes. I have yet, knock on wood, to have anyone tell me, no, I'm not going to review it. One time I did have someone say, well, if my attorney tells me to review it, I'll review it. And I'll say, okay, well, let's say for argument's sake that the court requires you to review it because the rules require you to review it. Are you going to review it then? Yes, of course I will. So you don't let that go. Don't let that slide. I try never to let corporate reps get away with that. The second type of person, I don't know if you guys have seen this person, but it's the new person. You know what I'm talking about? Oh, brand new director of security. I didn't work there at the time. Yeah, that person. I love those people. You know why? Because once you show them all the deficiencies in whatever the case is, and you're like, well, you weren't here then, were you? No, I wasn't. You would have done things differently, wouldn't you have? Probably. You wouldn't have just had a half finished incident report like this, right? You would have required a fully finished incident. You would have done a proper investigation, right? Absolutely. In fact, you probably do proper investigations now, don't you? Absolutely. You puff them up and don't. Wouldn't it have been nice if you were here back then, so they would have done a proper investigation? And then you kind of puff them up like, yeah, I guess we did things kind of poorly back then. That was before my time, though. Like, thank you. Well, you know what? My client certainly wishes you were there back then, because maybe they wouldn't be in this situation. And then you get them to own it. So I've found that time and time again. So those two types of the sacrificial lamb or the brand new
Right.
executive, right?
Well, one of the things we run into, though, especially with the slip and falls, is you ask for video, you ask for incident reports. They don't provide it. They say it's been written over. They don't have it anymore, haven't preserved it. And, sometimes in the 30B6, we want that person to come in and say, I don't know anything.
Yeah.
It just shows they don't care. They didn't do their homework. They just don't, care about anything in this case. On the other hand, sometimes you really need that evidence to survive summary judgment. How is it out there? It sounds like the casinos are pretty good with preserving videos and that type of stuff. Or do you run into that where they sort of, claim ignorance? Like, yeah, I don't know what happened to the video. It must have got written over. And how do you deal with that?
We still have that issue now. You would think casinos with their technology would have pristine, facial recognition video, but no, we still get 3 minutes of this, and we even have a case recently where it was the security officer took a video recording of the footage, so it's a video of the video, which is automatic spoliation. Um, and we have something called Rule 37E, which is specific for electronically saved documents or electronically saved items like video. And if you don't preserve it, there's like an automatic spoliation to that effect. So we will always file that motion in order to avoid any kind of potential motion for summary judgment against us. Uh, but what we've found still, though, is it's better. If it's bad video in this town, it's better because focus groups have told us, juries have told us, this is a major casino. Why do we not have better video than this? Because they naturally assume what we just said, that there should be facial recognition, like literally zooming in on you, zooming in on the, on the broken glass to be able to do that. And when they have fuzzy video from a mile away that you can barely see, that plays against them. They'll say, "Why isn't there better video?" And they'll
Right. Yeah.
automatically think it's a conspiracy. Like what's the casino hiding? Do
Mm.
you guys have that too, or no?
Yeah, I mean, I think generally kind of everything that we're touching on, when you do a 30B6 corporate rep, you're trying to lock them in on whatever their position is going to be. And I think a skilled trial lawyer, and I think it comes with time and doing a lot of these 30B6
Yeah,
depots so you know how to respond to these different approaches, is generally the approach is if you're going to walk a mile down the I don't know path, I'm going to walk down 10 miles with you.
yeah,
I'm going to go for 7 hours and I'm going to get an I don't know or I don't recall answer on literally everything to the point that it's so absurd that no reasonable jury is going to believe you're telling the truth. Or the most charitable interpretation is going to be they sent somebody that doesn't know, or they're just entirely incompetent, and this is why this happened.
that's awesome.
Um, and so I think it is a skill though, learning to adapt inside of the deposition to what the strategy is going to be, because you never know. You might get somebody who comes in, they're very articulate and they give, very wordy, long-winded, non-responsive answers. That's a lot of corporate word salad. And then, motion to strike, it's non-responsive. That might be the right tone. Sometimes you get somebody like you said, they come in and they're just like, yeah, I'm new. I wouldn't have let this happen. And
Yeah,
you walk down 10 miles with them on that. And you just keep asking them questions to solidify that and lock them in there. Um, I'm curious, a lot of what we're talking about is negative space. So getting them to admit what they don't know or they're not sure of, or they agree they wouldn't have allowed it to happen. How does that carry over into expert testimony as opposed to a corporate rep? Do you have specific examples when it comes to this casino case of how that bled over into the experts?
yeah, and my partner Christian Smith handled it excellently. But what we did was effectively what you're talking about, negative space, and that's there's no expert that reviews everything. It's very rare, and when they do, they review everything, but then they'll miss crucial things like they didn't interview our client, or if they did interview our client, they didn't ask questions like, "Where do you sleep? Do you have two? Is it? Do you have two floors in your house? Do you have to walk upstairs and downstairs?" They don't ask those like important questions that you're going to bring out and elicit in trial testimony. If it so, for example, in this case, it's two floors. So my client, who at this point is walking with a cane, has to struggle up a floor and down a floor every single day. She has to have special. She had handicap bars inserted into her bathroom, her private bathroom, so that she could just get down and go to the bathroom. And this is a perfectly healthy woman before. Someone who actually walked from Bellagio to Cosmo because that's how much she liked walking. And if you've ever been to Vegas, that is not a short walk. Not in any time of year. That is not a short walk. So it these nuanced things you can just, if like you said, Mike, if you do a lot of depos and like Satch Oliver says, depositions or trial, it is the best practice ever. Because if you've got like 100 depositions under your belt, you're going to be ready for trial, and you won't even realize it. You'll be ready. So anyone listening, do as many depositions you can. Do as many different types of depositions. Do 30B6 depots. Do defense expert depots. Do defendant driver depots. Do all the depositions and just practice. And you're going to see your first deposition and your 100th deposition a huge change. A huge change. I was on a mission during COVID. I started reading or listening to Rex Paris talk about negative space, and it got me so excited that I went on this mission to do 130B6 depositions from COVID to whenever I completed it. It actually took me 5 years. I completed it recently in March of 2025 this year. I did my 100th depot. We had a little office celebration for it because I wouldn't stop talking about it, right? And and I did notice on that day, I went back and I looked at my first 30B6 depot I did when I started the journey. So I'd done, depositions before, but my first 30B6 depot when I started the journey versus my 100th 30B6 depot, I thought I had done good on that depot back in March of 2020. No, it was terrible. It was 2.5 hours. I let the defendant corporate rep get away with just every single little slip. Didn't ask any follow ups. He'd tell me I don't know. I wouldn't jump on that in negative space. I'm like I do now. And then I actually I took that a step further. You negative space of I don't know, 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 I don't know. And then once I feel like I've gotten them in a rhythm of I don't knows, I'll ask, don't you think you should know? And that's just kind of like this heartfelt open, like, don't you think you should know this? Doesn't matter if it's a defense doctor, doesn't matter if it's a corporate rep. If you walk them down a certain path, like, don't you think you should know this? There's no right answer for them. Yeah, I should. Then they look kind of silly, you know? And if they say yes, I'll say, okay, well, I'm going to give you that opportunity. So at trial, you're going to go through all my client's medical records and you're going to get up to date on his or her injuries, right? And you're going to figure out, all the surgeries she's gone through and all the pain and all the suffering she's done. You're going to read her deposition transcript before trial. We can have a meaningful conversation then. Is that right? Is that okay? And then I'm like, yeah, I'll do that if my attorney says to.
So Patrick, I'm curious. Just talking about depositions, what's your take on? I know you're talking about taking the 30B6 depot and some of these other witnesses. Are there cases where you choose not to take an expert's deposition just because you don't want to tip them off to what your questions are going to be at trial, or if you do take it, do you limit it to the non-medical or the non-scientific stuff and just attack background and fees and what they've billed in the case? Or what's your take on that? Because I think even in our practice, we have some where we want to take that expert and nail them down. And some we don't want them to know what we're going to nail them with that trial because we've got a file on them or her, whatever it is. What's your practice like?
It's definitely both. I mean, sometimes, like for example, in the mold trial, we didn't take one defense expert depot because we knew our attack and we knew their attack. Their attack was mold's not real. Okay, well, we already know how to refute that. So that was the heart of their testimony. So we came prepared for that. So we took no depositions and we just eviscerated them in trial. They actually ended up only calling one defense expert. So, but for the slip and fall case, we did all the depositions. And I think when you do a defense expert deposition, I think that really depends on your talent, knowledge, and experience. Personally, I am not the type of attorney who's good with the medicine. I don't understand it that well. I have difficulty saying complicated medical words. I'm not, so for me to start attacking a doctor on their own ground that's a nightmare for me. So I will do what you're saying. I would talk about the bias. I talk about the stuff I know. So I think I've heard, I don't know which TLU video it was, but there's definitely someone out there who talked about it where they would have a doctor, they would depose them for 2 hours, and then the doctor would say, are we going to ever talk about my expert report? And they'd lift up their expert report that they brought and painstakingly went through for the night before. And I don't do that. I don't even touch their expert report. And if I do, it's just to say, so you reviewed 84 documents That's approximately 4,000 pages, right? And you said you spent an hour reviewing this. So you spent an hour reviewing 4,000 pages to do your expert report. Is that your testimony? So that's the only time I touch their expert report because I don't know. I don't want to fight them on the medicine. I'm just not. I'm not there yet. Now I have a partner, Christian, who did the Fenton trial with me. He is our nickname for him at our office is Doctor Smith because he is so dialed in on the medicine. Um, and he was actually the one who made the decision to call in that slip and fall trial to call their defense expert as our star witness for damages. And it was she was the best expert we've ever had, and she was hired by them. So, he's so good with the medicine, he can do that. I cannot. I would never try to do that. Uh, so I stick to what I know, which is, hit them around everything but the medicine. So,
I want to segue and wrap up with opening statements. And I'm curious when you do, let's say you do 10, 12 depositions, you have fact witnesses, you got a corporate rep, you got defense experts, and you're stringing together your opening statement. How do you go back and choose if you're using clips or you're using admissions or whatever you're using? What's the process for piecing that together into a coherent narrative for opening statement? Because I think as trial lawyers, like you spend years building up the case. You might have a 7 hour corporate rep depot and you have tons of really good content to use. How do you go about strategically selecting the points that you want to use?
so you know, you have to honor your own system, which is keep it simple. So what we do is we'll probably have 200 slides, and in the 200 slides, we'll probably have 20 to 30 clips from the parties, right? That we're going to play in those in our opening. By the time we actually do the opening, that 200 slides will be cut down to 80 if we're doing our job right. So once you get in everything you want and you kind of place it everything everywhere you want, the way we do it is we as a team will go through our opening slides. Do we need this or not? No, cut. Do we need this or not? Cut. Do we need this or not? Cut. And if we're not sure, I'll, keep it for another day or two and let me decide on another day. Let's go through it again in a day or two. And that's what we do. It's a constant evolution of how you want to do the opening. So that's how we kind of figure that out. In Nevada, we can only use party depositions for purposes of opening. So that's the clips that we use. We can't use like defense expert depots. So what we'll typically do is we'll just put up pictures of the defense experts. But I kind of did something similar to what you guys did. Was I would show all our treating physicians, I would show their defense experts, and then I will highlight who agrees with who about the injuries. You know, because there's always like if they have like 4 or 5 defense experts, there's one who will completely deny it all and say this is not. They're not even hurt from this. And then there's always like 2 or 3 like sprain strain, which is still an injury. So you're acknowledging an injury, right? You're just disagreeing on the degree of the injury, but you're acknowledging there is an injury. So then we'll highlight those. Like, look, everyone, all these people agree. And then you just speak it. And I try to do it not in, I don't want to use the phrase like dumb it down because I don't think that's appropriate. I think it's more just like, I don't want to use legal jargon. I don't want to use medical jargon. But I want to incorporate it. I want to incorporate it where it's necessary. So if I'm talking about duty, I'll say, look, we're talking about duty, right? We're talking about duty, but what is duty? Duty is a responsibility. So responsibility, they have a response. So, you incorporate it. And if you're talking about medical jargon, I will say, it took me forever to say toxic encephalopathy. So I'm saying it right now, but that's a lot of practice. Toxic encephalopathy. What is that? It's inflammation of the brain, guys.
Yeah.
That's what that is. That's what you're going to hear from doctors.
Well, that's a good point because I think that's sort of our process too. And Michael's really good. You've seen the slides he's created. I think they're very
I've
easy to
hijacked
process.
many of them.
Well, he's good. He's good at the graphics, and I think that's so important. But to your point, you have to have other people look at them and constantly analyze them because when you're doing the slide, you're creating it. You know what it's meant to convey. You know what the meaning is,
Yeah.
but someone else may not. You might have an arrow on it, or you might have a time or a date or something, and when you're doing it, you know what it means, but someone
Yeah.
who's just looking at it out of context has no idea. So it's really important, like you said, to have your team like, let's look at these and see and simplify them and get it, because that's part of the framing is getting it to the most simple, straightforward thing where the jury is looking at the slide and envisioning it, and you don't have to even argue or do anything. They've just got this picture in their mind, and that's the case.
Right. They see it and bam, right there. Actually, this reminds me. I told you I was a fan because I've watched the slip and fall on ice TLU video, God, 100 times. I will watch that to prepare for trial, and I love the part where you talk about where Mike talks about how he did his opening for you the first time around. And he just threw in every single, this is what they're going to say, and attacked every defense. And afterwards, he's like out of breath and just disheartened because he just didn't feel it. And you were like, yeah, we got to work on this. And then the next day you come in and you do that, you write on that big post it, like, what are we here for? Like, positive
Yeah.
mindset, get sleep, all that. I saw that. I do that every single trial now. On a big post-it, I'll say, why are we here, guys? Like, as a trial team, we'll get here. Why are we here? And I'll write it all down. Like, look, our client was, no matter what happened, our client's messed up.
Yeah.
We all believe
Well,
that.
that's like,
That's why we're here.
yeah, it's like framing your own mindset too, because you have to put yourself in that mindset to know what are you really there for and what are you doing. But yeah, go ahead, Michael.
Oh, I was thinking this whole time, like, really what it comes down to with all of this, from framing to mindset, is just extreme focus from, what story you're telling to how you're telling it to what your slides look like to what your mindset is stepping into the courtroom. And yeah, I can say that on the casino case, you did a phenomenal job. I mean, I remember seeing those slides and I wasn't distracted. Like, I got a clear message from each slide, from each statement. It was very easy to track the narrative. Um, and I think that's something that I'm always trying to improve on when I'm building my case and I'm putting my presentation together is, what is the jury going to be focusing on when I show them this? Are they going to be focusing on the thing that I want them to focus on? Or are they going to be are they going to be trying to read something that is going to distract them? Or are they going to be, is there too much color? Um, am I directing them to a defense that I don't really need to bring up? I can just
Yeah.
let that sit and let the defense bring it up. And so I'm always asking myself now consistently, like through every day of trying the case and building the case up, what am I focusing on? Where is the focus? What story am I telling? And it's been really fun jamming with you and talking about this. There's so much more
So
that
much.
I
Yeah.
wanted to touch
So
on,
much.
but
Yeah.
I know you got something going on soon. So thank you so much, man, for joining us. We definitely wanted to have you as the first guest. Hopefully we're going to have you back at I'd love to have you back like all the time because I could chat with you forever. But no, it was fun and really appreciate you coming on.
No, thank you for having me. I had a blast, and I really mean it when I say I watch your guys' video to get ready for trials. This is not the first time I've told you that, Michael. I like that
Yeah.
ice slip and fall case. That's kind of my playbook. That's what I go to whenever I need inspiration. I'll get up in the morning. I'll throw that video on. I'll work out, and there's always something new that pops out from there. No matter how many times I watch it, always something new that I get that I didn't get before. So I think that's something important to take away from this. But I, always have a fun time talking to you, Mike, and great to finally meet you.
Yeah, it's good
Great,
to meet you.
great, Bob.
That's
It's
right.
good to
Yeah,
meet you.
no, I echo your sentiments. It's just so there's so much information out there. You can always learn. I watched your guys TLU on demand the other day, and there's so many things you can learn just from everyone. And that's for us. That's what it's about. It's about sharing and working together for our clients to make all their cases better because we're all in the same fight.
Absolutely. And Mike, you said something to me in the last podcast we did for TLU together that really stuck with me. And I think you're right. And all three of us, I think, fall in this category. We are all true students of the game. We read everything, we listen to everything, we watch everything. I could talk about, sorry, you guys know. You can mention Keith Mitnick, something from there, I'll know. You can mention Negative Space, that's Rex Paris. We all know. So I love it, and that's rare. I don't get a lot of that. Even with the people who really, the big trial lawyers, they're not all. It's different to really, really be a student of the game, to just want to
Yeah.
be a sponge and soak it all up. And I think we're all in that same boat. So it's awesome.
Yeah,
So
definitely.
much fun.
Yeah, I could nerd out forever. Really appreciate you coming on, brother.
So
Hopefully
much
we'll do
fun.
it again soon.
Absolutely. Thank you
Thanks
for
so
having
much,
me.
Patrick.
All right,
Yeah, it was
take
great.
care.